Awesome. So welcome back everyone to Full Disclosure. Usually with Eddie and Hayley, Eddie is still away, so we have him here in spirit all the way from Ireland. But today we're so excited that we have Shoshana joining us from a very long name of an attorney's office that I will let her say. But she's going to enlighten us with her updates about landlord tenant issues in the city, what's been going on in the last couple of months since shelter in place. Things are changing, things changed last week, everybody's like, what's going on? Oops, 1 second, I'm gonna mute myself on Facebook. And we're super excited to get the update. So anybody that has any questions, feel free to just raise your hand or put a question in the chat on Zoom. Go ahead and do that whenever. And we're super pumped about this. So Shoshana, would you just tell us a little bit about yourself and your bio?
Sure. So the very long firm name is Zacks, Friedman and Patterson in San Francisco. It's always someone, and someone, right? So Zacks, Friedman and Patterson in San Francisco, right in the financial district there. And I've been there for about 3 years doing a lot of landlord tenant, in particular Ellis Act work, some land use and permitting issues, encroachments, construction defects, where we do real estate litigation, pretty much exclusively representing landlords and property owners. I think the interesting thing for my practice is that the interplay and overlap between the landlord-tenant issues and the land use and permitting issues. I don't know if that exists quite the same way elsewhere, but San Francisco has a very unique political climate where those issues really overlap, and you really have to think ahead on what you're going to do on one side and how it's going to affect the other. So that's a lot of what I do and what we do at the firm there. Before that, I started off in Southern California doing commercial property management for a while with leasing and all of that kind of thing, and then began my practice with business and real estate litigation down there before coming up here. So very different environment, both in commercial versus residential, and in Southern California versus the Bay. Very, very special context up here.
Yeah, well, absolutely. Just to clarify up front, so that any questions that come in have the right context, you are mostly on representing landlords. If a tenant wanted representation, is that something that they can get at your firm?
We don't generally represent tenants. On occasion, we'll represent a commercial tenant, and then very, very rarely a residential tenant, but we're pretty much, we're very much focused on landlords and property owners.
Yeah. Well, and I know that, it's I feel like when I'm from Boston, and when I go home, like, these issues just don't really exist in the same way at all. And so having specific landlord attorneys, tenant attorneys, it's just so specialized. And as we'll get into, like, things change so much, and tenants' rights are just so different here that I can imagine that the entire firm would need to focus on one thing, just given the level of business on both sides.
There's a certain amount of trust, and to be perfectly frank, I don't know if you continue to practice in this area and in this area physically, you're going to have conflict problems if you represent both sides. It's a matter of time before you come up against someone else that you should be talking to. So yeah. I think it works out best for us to represent landlords the best we can. For sure. So I have a number of questions that have come in from people that are excited to hear from you, but do you want to just, if you wouldn't mind, give us an update of what it's been like? We talked to your colleague Scott in the beginning of shelter in place. Honestly, I don't even know how long ago that was. When we talked to him, it could have been weeks or months, and who knows at this point. Time is a flat circle. Absolutely.
But what has it been like? I mean, you mentioned to me earlier that you've been doing Zoom court proceedings and stuff. What has the last couple of months looked like for you?
Yeah, so it's been an adventure for sure. At the beginning of this, the courts pretty much shut down. Everything was put on hold, and in particular with regard to unlawful detainers, all unlawful detainers were put on ice. That came from the court, not from the legislature, not from the city, but from the court. The courts are opening back up now. That's true statewide. For the most part, courts are opening up. However, the biggest, most significant thing that's happened recently is the Judicial Council, which governs all of the superior courts in California, issued an emergency rule. So this rule is in place until it ends based on one of these events. Either they have to remove it, repeal it, alter it, but more likely it lasts for 90 days after the lifting of the state of emergency. And what it does is prevent the issuing of a summons on an unlawful detainer. So practically speaking, what that means is you cannot move forward with an unlawful detainer action until 90 days after the statewide state of emergency is lifted. Who knows when that'll happen? Probably not for a long time.
Right.
I think it's probably likely that there's going to be challenges to this rule eventually, but at the moment we're sort of stuck with it. Complaints can be filed, but you can't move forward until a summons is personally served on the tenant or else some other mechanism. But that's an important thing. So what that's meant for us is that any new cases are not moving forward. We can't even send notices really, and even if you do, for what? It doesn't get you anything really. Existing cases, on the other hand, are moving forward. So anything that was filed before March 15th-ish is moving forward. I know that we had a lot of cases that were just on ice the court is finally kind of getting to that backlog. So the Zoom calls, the Zoom hearings you were discussing, I had a hearing back in February that was continued to get a court reporter, and we just had the hearing on July 27th.
Wow.
Yeah, all the way from February. So it's taking a really long time for them to kind of gear up and get these things organized. They had some issues with the Zoom calls. So now I feel that they're running pretty well. It was pretty efficient, but apparently they had an issue with Zoom bombing and had a couple hundred people crashing hearing. And so the court had to reorganize how they did the Zoom calls.
Zoom bombing, is that like a photo bomb? Like people
show up and do ridiculous things and just kind of clog it up. I don't know the details of what happened in this particular incident, but I heard that from the judge at the hearing, that this is why they modified their system. So now they're presented like webinars as opposed to open Zoom calls where the public can do or say whatever they want. Yeah, it's now it's more controlled than it would be in person. You can listen, but you can't stand up and shout.
Sure.
We'll hear you. So they've been very efficient, I think. I had a good experience with it, but it's definitely different to see, judges in chambers holding hearings. They're just sitting in their office, as opposed to having the feeling of being in court and looking at everyone at the same time. Usually you just look at the judge, so it's a little different. But these existing cases are moving forward, and they are kind of clearing this backlog as they move forward. As we kind of move on into the next sort of phase, the new cases, what we're seeing and what I'm hearing from the San Francisco Apartment Associations and other organizations that have taken polls is that residential tenants, for the most part, are paying. It's a pretty high rate. So this notion that there's a whole lot of non-payment cases from COVID kind of sitting by doesn't seem to bear out residentially. On the commercial side, it's a very different story. Landlords are having a much harder time, and tenants are having a much harder time paying. So it's definitely a different situation. But the next big issue in that regard, and with non-payment, is a new ordinance passed by the Board of Supervisors that would prevent unlawful detainers based on rent that was due during the COVID period permanently. So you would never be able to recover possession on the basis of that non-payment. You can't recover it right now anyway because of the Judicial Council rules, but this ordinance prohibits even next year or any time. There's a challenge to that pending. I think the hearing is tomorrow morning, so we'll see what happens.
Okay.
But that's hanging out there, and San Francisco is not the only city to have done this. It's also Alameda, West Hollywood, a few places across the state have chosen this route. That really kind of puts a burden on landlords to carry carry properties and carry taxes and carrying costs and kind of carry the tenants through that time without any kind of promise of payment. I think also it'll inspire some tenants to stop paying, knowing that they can't, even if they could pay, they may choose not to, knowing that their landlord can't really do anything about it. And we are hearing some tenants doing that.
So we kind of talked about that way back in the beginning. We talked about that with Sean Herrero, our awesome lender that we work with, in terms of non-payment forbearance for mortgage payments as well, and just like how that affects people as borrowers in general and renters in general going forward, and like what repercussions that will have going forward. But like, you know, so what I've heard from another attorney is that the like baseline for a tenant proving that they're affected by COVID is like the floor. Like anyone can say they're affected and not pay. Is that what you have seen, or is that true?
Yeah, it's pretty minimal, but I think more to the point is with this new ordinance, that's where we were at. Originally there was an order, more like an executive order from the mayor about that, laying out some procedure and some guidelines and encouraging people to work it out. But this new ordinance put forward by Supervisor Dean Preston changes that dynamic, because a tenant can raise as a defense that they were affected by COVID at any time.
Okay.
So even if they never told their landlord, and landlord has no way of knowing and just says, this person's been ghosting me, you know, for 3 months, what do I do? And they file a UD, hypothetically, they file the UD, and the tenant can come and say, based on their own declaration, they don't need any backup they just have to say, no, it was COVID. And that's kind of enough per this ordinance. So it's a very, very low threshold. Yeah.
On that note, we have a question that came in. So kind of related, it says, would you offer any pointers to landlords who have tenants making unreasonable rent reductions during COVID, or far below even the current market rate? Any tips to deal with opportunistic tenants?
Yeah, and we have seen, I did see a particular blog post kind of circulating, a couple of law tenant firms circulating sort of advice to tenants on how to avoid paying rent. You know, in an opportunistic way, which is kind of sad to see, or disheartened to see. There's not a whole lot you can do right now. That's the trouble. If you're in San Francisco or Alameda or one of these other places, long term, what you'll be able to do, well, we'll find out tomorrow. But long term, what you'll be able to do about them not paying is pretty limited. If you're not in one of those jurisdictions, you're in a different boat. So if you want to get heavy in terms of leverage on your side and say, no, you need to pay this, you don't really have a lot you can throw behind it from a legal perspective.
Does that go for tenants who want to break an active lease as well?
I'm not sure I follow.
If somebody signed a lease, a 1-year lease in January, they're paying market rent, whatever, but they want to get out of the city. I've heard this a lot, actually. And they're normally you'd be, stuck holding the bag for the rent that is due, unless you can find a suitable tenant, right, to take the place to pay that same rent. However, obviously that's a little bit harder to do now. And so I've heard from a lot of people that there are just, there's kind of this question of like, what happens if I want to get out of that lease? Like, am I holding the bag, or am I with the other guys who are just not paying rent?
Yeah, that's an interesting question. I haven't looked at it so much because so rarely the landlords that we work with want to keep someone,
Sure.
keep them in. We're more on the side of trying to get possession back rather than trying to keep the tenant in for the most part. From what I'm hearing, there's a lot of people leaving, and this is more your field than mine, but I'm hearing that people are still renting, people are still buying in particular. So they're, the opportunity to mitigate and to get another tenant in seems like it's pretty feasible, if maybe at a slightly lower rate than what you had before. I think in general, if they're leaving the city from a legal perspective to chase somebody for the balance of their lease, you're already in a legal quandary that probably doesn't merit pursuing, especially if they're leaving the state. It's just a lot.
So expensive and tiring, and
it's a lot harder once we get involved. So
right.
It's I don't think people always appreciate how stressful litigation is, and it's better to just work it out with your tenants as much as you can.
For sure, for sure. Okay, so this is, again, this is from, I think, more of a tenant perspective. So if we can't really answer it, that's totally okay. So it's a little anecdotal here. Do landlords need to provide validation for rent increases? For example, last year, a landlord increased our rent by 9%, citing average rent rates in the city, despite the fact that there was, this is horrible, a shooting outside our building. Rents in the area generally decreased. So as we look into the second half of this year and the massive inventory already in the market, subjective, can a landlord in a non-rent controlled unit increase the rent for any reason, even if that's just to get the current tenants out, and even if they end up renting the same unit for less to a new tenant?
So there's a couple of, I almost hesitate to give, I can't really give them an answer, but I can say that there's a few things that are at play here, and it would depend. It depends.
Sure.
Well, typical lawyer answer, it depends. Yeah. But the first thing is that now we have statewide rent control. So there is a cap on how much rent increases, even in a non-rent control, meaning local rent control, a jurisdiction. There's a limit to how much they can increase it. 9%, I think, is under that cap. But no, they don't need to have any justification. There's no requirement for that. Locally, in San Francisco, there are restrictions on increases for the purpose of pushing a tenant out. So that would be something to look into. They may not be subject to the rent control aspects of the San Francisco rent ordinance if they're in San Francisco, but may be subject to some of the just cause and other provisions. So there's a potential that that's problematic. And whether or not the landlord rents to someone else lower, that's a tough one to go about. And definitely something to keep an eye on in case of a potential wrongful eviction suit after the fact to say, hey, this wasn't a good faith increase. You were just trying to get me out. But there's a lot of factors at play there.
That reminds me of, I wanted to ask you about the Ellis Act and what the status is of that. If you want to just give maybe a brief overview if somebody doesn't know what that is, and how we're able to use it or not use it right now.
Yeah, so the Ellis Act is a state level law, legislation intended to override local rent control and allow a landlord to go out of the rental business by evicting all of the tenants in a building at once, or rather terminating the tenancies of all of the tenants in a building at once. It has to be everyone all at the same time, and there are significant restrictions on re-rental. So you can't rent the building again for 2 years. In San Francisco, there's very steep penalties if you were to rent again within 2 years. And then there's restrictions for 5 and restrictions again for 10, sort of lessening over time, really intended to limit the use of it to situations where the landlord really does intend to exit the rental business, doesn't want to be a landlord anymore. San Francisco in particular, there's a lot of negative feelings politically about the Ellis Act, particularly coming from the city. The city can't do anything about it from a legislation perspective, from a governance perspective. So instead, they fight it in court. That's what they do. They have a very anti-Ellis Act policy, and that extends to land use as well. So there's certain restrictions that come with invoking the Ellis Act. For example, condo conversions are pretty much out the window if you've done an Ellis, and some other things.
Is that just for within 10 years it's out the window, or is it forever? Because I've actually heard differing opinions on that.
It depends on when you did it. So if you had done the Ellis, say, I think it's before 2013, but don't quote me on that, then you'd have different set of restrictions. As a practical matter, if you've ever Ellised, you're probably not going to be successful in some of these land use endeavors anyway, just because of the political climate. Because there's such animus towards its use. Originally, a lot of what you saw with the Ellis Act was larger buildings, or corporate landlords, bigger projects. But because of how tight rent control is in San Francisco, I'm seeing more and more families and just individuals who maybe have a single family home with an in-law unit. And that in-law unit means it's no longer a single family home. Now it's a duplex. and maybe they just want to live in it. And the only way to do that is through a mechanism, as a heavy-handed mechanism like the Ellis Act.
Mm-hmm.
So it kind of changes, it varies.
So for currently where we are right now, what does it look like for a landlord who is intending to, because I've seen properties that are on the market right now that have been LS'd, or, you know, from a developer standpoint, would normally maybe strike some interest there. What is the status?
Yeah, and I did just say a lot about the negative aspects of the Ellis Act, but that's if you're wanting to rent. As a landlord, you know, as a landlord-tenant tool, it's not very productive. But a lot of people, like I say, want to live in a building or develop it as TICs, something like that. There are no restrictions with regard to that. They can't be. So there's
You
plenty.
can file for one now, like you can serve the notice.
Because it's a state law, the city can't put a moratorium on Ellis Act evictions. In fact, they're specifically excluded from the mayor's orders that we've seen throughout this COVID time. So new Ellis Act evictions can be filed now if you like. If you have an existing, trouble is if you have an existing Ellis Act, the notices take anywhere either 4 months or a year. So if you had a notice that expired a year ago and the tenants don't move out, there's nothing you can do about it really right now.
Okay.
There's some alternative, in terms of an unlawful detainer, there's some alternative ways of getting at this issue, but you don't get to take advantage of the summary proceeding, the shortened time. So it becomes a regular lawsuit, called cause of action is ejectment, where you're on a much longer sort of time frame and you don't get preference in terms of dates with the court.
Okay.
So it's a longer process now, but if you start your notices now, knowing they're not going to expire for a year, who knows what the situation will be. And presumably a year from now, we'll be back doing unlawful detainers as normal, hopefully. Optimistic.
Yeah, seriously. So in terms of, I have another question here from someone watching. So kind of a two-parter here. Do rent reductions, if that's something that a landlord and a tenant are negotiating, does that require an attorney's input? Like, is it recommended that a landlord should consult an attorney to do that? And what if they only want to reduce it? Like, can they put provisions saying that they can reduce it, they're going to reduce it for 6 months and then it will go back up to market? Like, how does that work?
Yeah, so I would recommend hiring an attorney for that because it's a bit of a minefield. Normally, if you have a month-to-month tenancy, it's different if you have a lease term that you're still within. But most of the time, particularly because of the rent control laws, we're looking more often than not month-to-month. Mm-hmm. If you have a month-to-month tenancy, it means it's renewed each month. It's a new tenancy each month. So generally speaking, if someone pays you less, you've now renewed the tenancy at that lower rate. And you have to be careful that you're not changing the terms of this tenancy by accepting a lower amount or a higher amount or whatever it may be. So you do want to make sure you have an agreement, a written agreement in place ahead of time. The rules have definitely been altered a bit in order to allow for these forbearance agreements. That's what they're called generally. But you want to make sure that you're covered. You may have a great agreement with your tenant now, a handshake deal even, and everyone's happy and getting along, but you don't know what might happen in 3 months, 6 months, a year from now, and then all of a sudden all you have in your record is a payment that was non-conforming and was accepted. So I would definitely recommend hiring an attorney. There's other issues that could come up as well, and it's an opportunity to possibly get some releases about complaints that your tenant might levy against you with regard to the rent payment as well. So it's best to cover yourself and certainly to put it in writing.
Okay.
I've seen a few people making some handshake deals, and then there's a huge issue of interpretation later on.
Got it. Okay. Let's see. A couple more questions here. Are there any new precautions that a landlord needs to take right now, given the environment that we're in, when writing a new lease?
That's a good question. Commercially, definitely. I've been working on that a lot lately. As much as businesses are suffering, there are other businesses kind of stepping in and taking advantage of the opportunity to open something new or prepare for something new. So there's been a lot of back and forth about new commercial leases not having their force majeure provisions triggered initially. So you might have a lease, it's very common in a commercial lease to have a provision that says, well, in the case of riots and pandemics and acts of God and nature and hurricanes and whatever, that rent may not be due or other obligations may not be required. But if you start the lease within that kind of scenario, pandemic or civil unrest or whatever it may be, there's an issue of interpretation there. Are they not obligated to pay their rent day one coming into this? That makes no sense. So there has to be some very careful drafting to make sure that you avoid that issue. Residentially, you don't have that problem and it's governed a little bit differently. So I don't know that there's anything in particular in the lease that you would want to change with regard to this, unless you have some sort of forbearance agreement. You're starting a new lease and you're going to give them a break for the first few months. That's pretty tough in a rent-controlled jurisdiction. You want to make sure you're not accidentally putting in an unlawful rent increase built into your lease. That's something that even if your tenant agrees to, they're not permitted to waive their protections under the rent ordinance. If something should happen down the line, disagreement about something else, they may file a rent board petition and say, hey, there was an unlawful rent increase down the line, and the rent board will not only bump the rent down, but all of your increases are going to be based on that lower amount going forward. So that's something to be careful of.
Definitely. Kind of a random question here, but nevertheless. Can you evict a tenant based on an undisclosed pet?
This is an ongoing issue. I see it a lot, more often than not. And I'm not sure when they say undisclosed if that's something that an applicant didn't disclose or you discover later that your tenants had a pet for a long time. I've seen both of those things.
Okay.
More often than not when that happens, because of all the publicity around it, you say, tenant, this is a no pets policy. You signed a lease that says no pets. And they say, okay, it's not a pet, it's my emotional support animal. And that puts you in a very different body of law and a very different territory. So as a practical matter, the short answer is no, for a lot of reasons. Number one is the emotional support animal sort of notion. Any tenant can request a reasonable accommodation at any disabled tenant at any time. So that includes after you file an unlawful detainer against them, file a lawsuit. You could say, I'm evicting you because you have this pet you're not supposed to have. And they can say at that point, oh, but I need it for my disability. In which case you're in a bit of a bind. So that's on the one hand. On the other hand, as a practical matter, right now you're not evicting anyone. And the chances of success in a San Francisco courtroom on the basis of cause like that is unlikely to succeed regardless. So
regardless of like destruction of property is what I'm getting here.
Well, if you have a dog, say maybe a bigger breed dog that hasn't been well trained and is chewing things up. Well, it's not about the fact that they have the pet, it's a nuisance. So it's a little bit different. But if they have, I don't know, a cat that you didn't know about and the cat just kind of sits there and doesn't really make noise and, doesn't do much, doesn't really bother other people, you're going to have a really hard time arguing to a jury, or to a judge that this person shouldn't live here anymore because of this.
So actually that I have had that come up with clients before where they do not want to lease like an in-law or whatever it is, another unit in where they're living. So like if you live in a duplex in the other unit to somebody that has a dog or a cat because they're allergic. Is that permissible?
Well, then you're in a pickle, I think. It's a little bit different. So like I said, I think the issue is that when you talk about pets, it's very possible that you could say, no, I don't, we're not renting to anyone with dogs, dogs or cats. And the person says, okay, I'll go on my own way. But if they do request an accommodation, the standard is whether it would be a change administratively or some sort of onerous burden on the landlord to provide the requested accommodation. I think if you're living there and there's an argument that, yeah, this is onerous and it is a change, I would have to do a lot of things to accommodate that. You know, and they might even argue, yeah, well, I need an accommodation too. I've seen dueling accommodations. This person says, I need a dog, and this person says, I can't be around a dog. And as a landlord, you're sort of in between trying to keep everyone happy.
Okay.
Yeah.
It's a tough place to be a landlord and a tenant sometimes, but wow, the city is really, it's a lot.
Well, and I should be clear on the request for reasonable accommodation, which is kind of, I think the emotional support animal is the most visible, tangible example that people see. You know, we were hearing for a while about, you know, emotional support peacocks on airplanes and things like that. I mean, that's definitely what we hear, but this is federal law. It's state and federal law that that controls this. So this is it's not just San Francisco. This is anywhere nationally. If someone requests an emotional support animal, the short answer is you tell them yes.
Got it.
You tell them yes, maybe with conditions.
Okay, that's really helpful. We have another one here.
Tell them yes quickly and in writing.
Okay. Is there an unforgettable case that you've had in your experience that you always give as an example or warning to other landlords?
There are a couple. It depends on what you're trying to accomplish as a landlord. I think in particular, I often warn clients about a particular case I had where client purchased a 2-unit building with the intention of expanding both units and moving into one. So kind of duplex like this, they were going to add on the roof and dig in the basement. And when he purchased the property, the lower unit was occupied. He bought the tenants out. And they left. And then he submitted his plans and continued with the planning department. Once his plans were issued, a neighbor next door who did not care for some of the design aspects filed a discretionary review, and the planning commission ultimately denied the project on the basis of the buyout and the form of the buyout. They didn't like the landlord-tenant side. And so they denied the project, even though it was code compliant, and there was nothing really wrong with the project itself. They did not, this is not concealed, it's in the record. You can see they very clearly say this is our problem with it. The former tenants didn't come to the hearing. This is something that came from a neighborhood group. The former tenants had reached out to a neighborhood group at some point. That neighborhood group retained the documents and brought them themselves. So the tenants weren't even involved. They didn't complain, but a neighborhood group did, and tanked the project completely after a few years of doing this. So I cite this to clients often because you need to have a plan in place of what you want to do with the building on the land use side before you start some sort of heavy-handed landlord-tenant approach. Yes, prior council that did this buyout, sure, they got in possession, and they got in possession timely. It was a large buyout offer. I think he paid about $150,000. So it's not like nothing, but the planning commission didn't care. They didn't think that was enough, and they didn't think that buyouts are so disfavored. They still feel like these tenants are being displaced, in particular because of some of the heavy-handed language that was used to leverage this buyout. And so I tell that one as a cautionary tale of having your plan in advance and treading lightly on the landlord-tenant issues if you know you want to do a big project. Okay. If you plan on keeping the building as it is, it's less of an issue. But that's now something, now what do you do with this building?
So basically, when you say heavy-handed language, are you does that mean that the tenant is saying that they were under like pressure and duress, basically, to agree to the buyout? Because, it's, for people who don't know, it's negotiated back and forth and can take a very long time to negotiate. But from my client's anecdotal evidence, so is that what you mean by that heavy-handed language?
It really kind of depends. So sometimes a landlord may approach a tenant after filing the requisite pre-buyout disclosures with the rent board, of course, and say, if you don't accept my buyout, I'm going to do something else. I'm going to Ellis Act the building, I'm going to do an owner move-in, I'm going to, some other mechanism. But when that mechanism is not something that you're intending to follow through with, in the event they say no, I think that's problematic. If you say buyout or Ellis, you better be prepared to Ellis. It's going to make your buyout offer look, it's going to make it look like like a heavy-handed threat if you're not prepared to move forward with it. And which mechanism you choose as your alternative is important. I think in that case, they were trying to pursue a substantial rehabilitation route or capital improvement, something that's already a difficult road. And telling these tenants, hey, if you don't take this buyout, we're gonna go through with this crazy construction plan, and it's gonna disrupt your life. It may be true, but it better be if you're gonna start making, you're just gonna start putting that out there.
Yeah.
You want to make sure it's not just leverage, that it's really your plan.
Sure.
That's what we're going to do.
Okay. What's the biggest tenant buyout you've ever witnessed?
Biggest buyout? Well, the buyouts are usually a function of two things. So it's time and money. So the biggest buyout is going to be, is it the longest time or is it the most money? I've seen buyouts of maybe 200,000 with a couple of years. That's pretty substantial, but I know that there are far more, and I know in our office we've seen larger buyouts. I've seen landlords offer 200,000 in a year or two without blinking. But I've also seen tenants move out, for 10,000 or maybe for nothing, maybe just for a good reference or assistance in finding another place, or something else. Sure.
So what, if you had to tell somebody who's interested in getting involved in the landlord business in San Francisco, because I do have a couple of clients who've approached me, because it is an excellent time to buy, in terms of we have a ton of condos on right now, which are generally great rentals, a variety of reasons. The rates are very low. So, if you had to give 2 or 3 pieces of advice to somebody who wants to get involved in that business, what would you, or maybe even resources to use to read or whatever before you get involved, what would you say?
I think the number one thing is, if you have a plan for a property and you have a notion of what you want to do with it, consult an attorney before you purchase, not after.
Yes. Before you offer.
Yes.
Please.
Yes, before. If you're saying, oh, I'm buying this property because I would like to move in and it is currently occupied, you need to be speaking to an attorney beforehand. Yes. Thinking of a client I have who said, I bought this building to live in it. I know I have a job in San Francisco that's going to take 2 years, so I need to be in the city for 2 years. I said, great, is that still what you want to do? And he said, well, that job ended a year ago and I still don't have possession. So that was not a useful purchase for his needs. Now he's a landlord, whether he wanted me or not. So definitely consult someone before you commit to the property if you have plans that are different than what's going on there at the moment. If you're going to maintain the status quo, I think you're probably fine. That's the number one thing. Number 2 is I would definitely check on what information is available both publicly and from the seller. Very often I see clients that come and you look at the disclosures they received, and they're insufficient with regard to landlord-tenant issues. And there may be significant landlord-tenant issues that they either didn't know about or didn't know how significant they were, what the consequence of these issues is. So if you're seeing a building where there's no leases and no estoppels and nobody really knows who lives there, that should be a red flag. You could have problems down the line. If you're having trouble getting access to the units to see the condition, that could be a problem.
I just saw a property this week, frankly, that there are people renting by room. There are no leases. We don't know how long they've been there. There's no disclosure about anything. And we're being told that they'll be gone by close of escrow, but how do we, I mean, obviously on my side, we'd address that in like our offer and whatnot. But that to me was just like, whoa, I don't know where these people came from and how long they've been there, and they're living there. So,
and again, I think the issue that people need to understand is that if maybe you have a bunch of people with, that are kind of rooms separate and whatnot, and that can pose problems, you may get a better price, and it may be worth it to you to put that money towards, the risk of lawyers on the other end, as opposed to the purchase price, or adding value some other way. But it's understanding that that's what you're buying, that you may be buying a lawsuit. Very
like,
often,
who wants to do that?
Some people do. Some people are willing to.
Well, definitely. Absolutely.
I'm glad. It's a lot more fun that way.
For you, maybe. I don't love that part. But actually, that does remind me. So if I am a landlord and I want to sell my property for whatever reason it might be, a tenant occupied property, what do I need to do in order to protect myself, make sure I'm disclosing everything that I have and whatnot? Should I get an attorney before I get a real estate agent to sell my property?
That's interesting. One thing I wanted to add, what I was saying before I move on and forget, is that I think it's also important that buyers understand that liability for landlord-tenant issues is going to continue. So even if you didn't do the thing, you still have liability potentially for whatever. So if you're buying a property where there's all these weird leases that are maybe not right, or habitability issues, tenants get scared very often when there's a transfer and a sale, and so it's not unusual for the minute a sale goes through to see complaints to the building department and a lawsuit on file.
Right.
So just something to keep in mind. With regard to a seller's sort of liability here and protecting themselves, you have no obligation to disclose anything you didn't know about. How can you? So as long as you provide everything, and make sure to disclose everything that I think you're in a good position. If there's something that you think but you're not sure, that's, I think, a stickier issue, and probably want to tread a little more carefully depending on the kind of issue. With landlord tenant issues in particular, I think it depends on if it's a long-term owner or not. Sometimes we see sellers that have owned a property for 40 or 50 years, or even 20 years, and they have a long history with these tenants. And then you have a new owner come in, and the tenant has far superior knowledge of what's going on in the building. And then you try to find your seller, after the fact, and they may or may not have the records anymore. I would hold on to those things for a while, and be prepared to be involved. If you leave a mess with your tenants, be prepared to be involved in some lawsuit that may come along down the line.
Yeah, so that's interesting. Like, I honestly haven't really thought about it from that perspective. That question came from me. So just because generally we're representing, or in my experience, representing buyers on tenant occupied properties, and we're always talking about what they're taking on and the risk that they're taking on. And if there were illegal rent increases, if there is an illegal unit that is rented, the claims that tenant can have, and it's now my problem because I bought it even though I didn't do it. So that's kind of the perspective that we often look at, and not from a seller's perspective. So for me, I'm just say, when in doubt, like, talk to an attorney. So
I would say on the seller side with disclosures, one of the issues we see is sometimes we have this question of, did you put in the unpermitted work? Did you put in this unit, or was it something that was there when you bought it? And if for someone who's owned a property for 20, 30 years, it makes a difference if it was there when they bought, if this, illegal in-law has been here since 1942, that's a very different situation than one that was put in 2002. And I think those are the things that sellers need to be careful of. That there's the things, anything that happened during your ownership, you're going to want to, that it's going to affect permitting, land use, anything with the building department, anything with the rent board, any kind of city agency. You want to make sure that you're disclosing.
Right.
I think unless you have a very particular kind of sticky situation, you don't need an attorney before you have an agent. But if there's something is problematic, you have multiple tenants, you have illegal units, it can't hurt to ensure that you're meeting your obligation ahead of time and avoid problems down the line. Okay. Actually, with disclosures, the most often the problems I see from sellers is property lines. We often see issues with boundaries and property lines. So that's something to be very mindful of, particularly with regard to any kind of encroachments you might have, any encroachments you're aware your neighbor has. You're flashing, very commonly in San Francisco, you attach flashing to the next building in like a row house type situation, and you may or may not be entitled to do that. And the neighbor may come back later, and then it's a whole thing.
Yeah, that's actually something that I get that question a lot from buyers, like, where's the property line? And I always say, I don't know, actually, because you need a surveyor to tell you that.
Yeah, ask the county.
Right. And even if the seller is saying that it's that fence over there, the true answer is going to come from a surveyor.
Yeah, it's very dangerous to say, that's a property line, that's a legal unit. I get very nervous when I see listings that say, 3-bedroom or, office that could be a bedroom, things like that, because in San Francisco, that has significant impact on whether it's actually a bedroom. Is defined not by whether you can put a bed in it, and how that affects the value and how that affects the land use opportunities. What you can build within that envelope and so on matters. So I get very nervous when people say, it's been a bedroom, so it's a bedroom. Well, there's 3 rooms, one could bed in. That's a different story.
Yeah, I mean, we've all seen bedrooms in the basement, right? That are no windows, no closet.
No windows. The issue that I see with that is on the landlord-tenant side is occupancy and the occupancy limits. So maybe you have what is actually a 2-bedroom apartment. The tenants think it's a 3-bedroom apartment, and now they have way too many people. And it doesn't meet fire code. And that is a very difficult eviction lawsuit to win, but you incur a lot of liability by allowing it to continue if you don't. So you're kind of in a catch-22. Yeah. We often see this, maybe 12 people in an apartment where you're going, well, that may or may not be a good idea here.
But from a landlord perspective, like, you may not know, and oftentimes they don't know, right? Because there's subleasing happening or whatever, or the master tenant has gone and there's now 4 other people you never even heard of. And unfortunately, if landlords are taking rent from those people, then they're tenants, right? So you just have to be so careful as a landlord. And how do you, actually as a landlord, can you check in on the unit, and how do you investigate how many people are there legally?
I think it's sort of contextual based on what you may want to do, and what's going on at the property, what you're trying to do with the property. If you're just trying to make sure that everyone is safe, trying to make sure that fire codes are met because it could be a danger. Yes. I've had a couple of cases like that where they were very concerned that there was too much stuff because there were so many people. In an emergency, how are they going to get out? But that's not how the tenants are going to see it. I've seen, rarely, but I have seen some success with estoppels by approaching tenants sort of softly with estoppels that are for the fire department, so that the fire department knows who's in the apartment in case of a fire, so they know who to look for. That was actually a very smart approach. I think you have to be careful in using that for other purposes, but it may be of assistance. It's going in and just looking to look. May not be to your benefit. If you see that there are subtenants that you didn't know about, now you know about them, and you may not know all about them, but there's a body there, and there's a human being that you're going to have to do something about or not. You need
at some point. Yeah,
at some point,
especially if you choose to sell it.
Right, and if you don't know their name and you don't know who they are and you don't know if they really live there and they're visiting, that's a lot. So
yeah, for sure. And yeah, well, I have an anecdote that I'm going to actually hold back on because it's still fresh. So
too soon.
Yeah, it's too soon. In the last kind of 10 minutes we have here, I would love for you to just kind of tell people how they can find you if they have questions. And then I'll just do a brief market update because I know that some people were wondering what it was like in the last week or so.
Good, I'm very interested, so I'm glad you're doing that. I can be found at Zacks Friedman and Patterson at zfplaw.com. You can see our bios of all of our attorneys there, and contact us through the website there. So any questions, anything else, any follow-ups, feel free to reach out to me there. And we have also some additional information on some of the stuff we talked about today, particularly the Ellis Act. And actually, I think we just put up some stuff about emotional support animals as well. So yeah, or we will.
Well, you know what? I think so many people are getting pets during COVID. Like COVID puppies are definitely a thing.
Very much. And a lot of them are not well trained because they are puppies, and that's been an adventure in itself. So.
God, yeah. So, okay. So the market here, well, first of all, thank you so much, Shoshana. That was like incredibly enlightening. I'm super happy that we recorded it because I think that people will find this really, really helpful, especially agents. I see that there are a couple of agents watching, so thank you for joining us. But it's always, I mean, we always have to say, you know, like, we don't really know what we're talking about. We're not giving legal advice, like, but it's great to have resources that we can point to when we have those questions. So just as a brief market update, I'm just going to throw some numbers out there. In the last week, we have 71 new single-family homes listed. We have 132 condos and TICs. That's a combined number listed in the last week. For the condos and TICs, the majority of them are landing in the South Beach, Soma area, which is no huge surprise. But they do vary. They are all across the city. In the last week, also, we have 12 single families that are under, of the new listings, we have 12 single families that are under $1 million. However, 6 of them are listed at like $995 and $998. So do with that what you will. And there are 19 new multifamily, so the 2 to 4 units, 2 to 4 residential units, and mixed use in the last week. In terms of coming soon, so a lot of times right now in our new world, that's going to indicate what is being sold off market because the rules that we have to put them on coming soon status. So these are not going to be showing up in Zillow and Redfin. They're not syndicated. They are on the MLS for agents to see. There are 82 coming soon single family homes all day. And there are 123 coming soon condos and TICs. And 18 2 to 4 units. In July, so since July 1st, since we're basically at the end of the month tomorrow, unbelievable, we saw for the average, for single family homes, our average sales price was 4% over list. So, you know, we are still seeing, like I can tell you just from clients that I'm working with right now, multiple offers, I'm talking like 10 to 15 offers. That's in San Francisco and the East Bay. Single family homes are just in super hot demand right now. The median for single family homes for July, sold homes in July, was $1,675,000. And the average price, the mean, was $2,114,000. And the average days on market for single family homes in July that closed was 27. So that's actually, that's high. So super hot market right now. Definitely, you know, a great time to buy whatever you're looking to buy, just because the rates are so low still. So that's fantastic. Sean couldn't join us today, but he sends his regards and he'll be with us soon. And again, I just want to ask everyone to send me questions, send me requests for different people to have on. We've had such a great variety of guest speakers join us, and they're incredibly helpful. And you know, this is a resource for you and whoever's watching. So please just let us know what you'd like us to have on our webinars going forward. We do post these on our blog. So if you go to elevationrealestate.com/blog, I think, but otherwise just click on the blog. You can find all of the recordings there. We'll post them usually within a day or so. We're also live on Facebook right now, so that'll be there. And we're always posting new content on our blog, just in terms of market updates and stuff. So if you're just looking to get your finger on the pulse of the market, head there. And then additionally, I've been showing kind of the goods, which is our sold report that we send out weekly. It goes out today, actually. It goes out Thursdays. Make sure you ping me if you want to be on that email list, because it's a really excellent way to get an idea of what's going on in the market. You can see top 10 or top 20 overbids and underbids in the city. You can see things that have been on the market for over 30 days. So the over 30-day club is what we call that. As well as just like fun facts, like the smallest thing that's sold, the biggest thing that's sold, the thing that's sold for the most expensive, the least expensive. So it's always really fun to look at that stuff and just get an idea of what's going on. So that is it from me. Eddie will be back next week. Yay. We've missed him. And again, Shoshana, thank you so, so much for joining us. Really, really appreciate it. And we will see you. Oh, there you are. Thank you again. Really, it's been great and so, so insightful.
Thanks for having me.
Awesome. All right, guys, we will see you next week. Thanks for joining us.